Have you noticed how quiet the Mueller probe has been lately? You know, as recently as August, there were those guilty pleas from top names like Manafort and Cohen, but lately, nothing. That is, of course, for a reason you're probably familiar with. We are a month out from a big election, and DOJ guidance, not a law, but the guidance, discourages any big moves that could interfere with political races. But tonight, we have a new development that actually could give Mueller more precedent for any report he ultimately sends to Congress. A federal judge ordering a partial release of a Watergate report that informed Congress's impeachment proceedings against Nixon. This is the blueprint, essentially, for Nixon's removal. Even Ken Starr never got to see it because of the rules they have for the archives. But this federal judge now ordering archivists to unseal a so-called roadmap that a federal grand jury sent to the House Judiciary Committee in early 1974. And this is not a coincidence. Legal scholars sued for the release of this roadmap because of the current moment we're living in. They suggest that both Mueller and the public could benefit from knowing how Leon Jaworski, the famous Watergate special prosecutor who finished that up, used the information that was found in the investigation to try to give Congress clear facts and legal context for whatever they wanted to do, which was widely believed a potential impeachment at the time. Let me read, quote, "The primary significance of the document lies in its role as a kind of template for subsequent impeachment referrals." This is what those scholars argue, and they say, look, if Mueller decides to send a report to Congress, which he can do through Rosenstein, the roadmap would be a vital touchstone for the public and Congress to assess his actions. We have some perfect guests for this. Jill Wine-Banks is former assistant Watergate special prosecutor, and Barbara McQuade, a former federal prosecutor and professor of law at the University of Michigan, both MSNBC legal analysts, or as we call them, legal eagles. So nice to see you both. Thanks for joining me on a Friday night. Jill, on the Watergate front, how is this different from all the other voluminous Watergate material that's come out? And do you think Mueller really hasn't seen it and would want to?
I'm sure he hasn't seen it because he has followed the rules completely, and so he won't have seen it. It is correctly described in the decision by the judge as being basically just a very short index to the documents that we provided to the House. And the difference now is that you had a House that was actively investigating the president, a House that we felt we could trust to take the evidence and do something with it. Right now, a report to the House could end up going absolutely nowhere because they've shown time and time again their total lack of interest in getting to the truth. So we turned over a briefcase that we called a roadmap to impeachment. We did not specify crimes. We said, here's the evidence that we have that's relevant. And we did it on the day that we indicted all of the president's top advisors and named him a secret unindicted co-conspirator. We didn't identify him by name until a bill of particulars later. And so the only way that we could get the information to the Congress, which did not have the legal authority under the court decisions to get the same documents we had, was to use the inherent authority of the grand jury and to get the judge's permission to turn over this information. And I think that Mueller has the same opportunity to use the inherent authority of the grand jury to let Congress know the facts that he has. Now, we don't know what those facts are. Ours were very dramatic and very clear. But if he has that kind of evidence, I'm hoping that he will give it to the Congress and that he will use the authority he has under the current rules that appointed him to let the public know as well. There is that opportunity, and I think it's important for the public to know what the facts are.
Barbara, do you view this as a potentially interesting thing for them to use? And is the roadmap here as important if we don't know what Mueller finds? In other words, if you find bad stuff about the president, there's a lot more of a reason to get Congress involved. If you don't, you have all the normal charging function to deal with anyone other than the president that actually you believe was chargeable.
Well, I think because this whole area is so unprecedented, there are not case law that you can look to figure out how you do these kinds of things, that I think any kind of information and any kind of precedent that you have has got to be useful to Robert Mueller. Now, certainly there are going to be facts unique to the Nixon investigation and the Watergate investigation that are not pertinent here. You know, whether Howard Hunt paid somebody or demanded a certain amount of money, that fact itself is not going to be relevant. But the process that they used and this proceeding procedure, as Jill described, using the inherent authority of the grand jury and the court to order that information get turned over to Congress. Just those kinds of things I think can be very useful as Robert Mueller figures out his course and what he wants to do at the end of this. He's gathered his information, and now what does he do with it? Does he indict the president? Does he turn it over to Congress? And I think using this roadmap as one potential avenue has got to be helpful.
It also seems, Jill, that this mostly would arise under the current law if there was a disagreement between Mueller and his supervising authority, which currently is Rosenstein, but could, if they fire Jeff Sessions, could go back to being the AG, because the way those rules are written, as long as he has that clearance, he can send something over to Congress, right? The issue would be if there is a conflict or there's a new attorney general who takes a narrower view, it's not automatically improper if that person decides, well, we don't want you sending the report to Congress, and then you get into whether Mueller has any plan B.
Right, exactly. And I think that is a very significant point. I'm glad that you pointed it out, because it is the plan B. Hopefully, under the rules that appointed Mueller, he can and will be able to get information to all of the Congress, not just to the chairs, but to all of Congress. But I think it is important that he be aware, Mueller, be aware of this option that he has to get the information out in another way, because it is important. We can't keep hiding these things. If there's nothing that he has found that is damning of the president or anybody else, then we need to know that. But if there is significant evidence, we need to know that too. And as long as the Office of Legal Counsel is insisting that he cannot be indicted, then there's the only way to proceed, if you can't indict, is through Congress. And so getting information to Congress, because again, remember, the Supreme Court made it clear that a criminal investigation by criminal prosecutors has a right to get documents that the Congress cannot get. Mm-hmm. Now, if it was directly asked by the judiciary for impeachment purposes, the court might rule differently. But when it was the Senate just for an investigation, they could not get those documents. Only we could. So it's an important legal distinction.
Well, you've walked us through exactly where those roads lead, and it's so significant potentially if the chess pieces change in November. You could have a House that is more aggressive if the Democrats take it back. You could also have Mueller's boss shift from Rosenstein to a new AG who might be far less aggressive. So a lot to try to understand. Jill Wine-Banks and Barbara McQuade, thank you both.
Thank you.
Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.